We're live.
All right, we are back in Senate Judiciary, January 22nd. We have the Defense General here with us to talk about S-183.
And this is the, I'm not there, but this is the contractor from bill. This is the bill that's near and dear to my heart, to be honest. I was here when when contractor for fraud was originally created. And I want to say there's this little flashback that one of the things I would tell Senator Sears is that, you don't have to make a bill out of everything that happened in the last, year since we were here in the legislature. And this is one of a number of bills that were created out of bad situations that arose regarding Dixie's mother during the time between like the last session and that session. Other ones like, telecommunication fraud, all of those things. And this was one of them. And there was an original bill that was passed, a contractor fraud bill. And it basically, and I argued at the time that what it did is it criminalized negligence in the creation of, when a contractor came in and didn't finish the job or did a terrible job, like was not qualified to do the job, that kind of thing. And at that time, I'm like, there are some things that are civil and there are some things that are criminal. And typically, criminal things are those types of conduct. And I might be the last public school student who ever had Latin, but are malum in se, right? That they are, people recognize them as criminal in and of themselves. So, killing somebody or raping somebody or punching somebody in the face or stealing their stuff. And then there are other things that are what we call malum prohibitum, which are legal wrongs that don't involve like moral culpability, where people suffer losses, not as the result of the intent of the person who caused the harm, but that there was a loss. And I, at the time, argued that these negligence cases where contractors don't know what they're doing, and I don't know, I think probably all of us had at some point hired somebody who didn't know what they were doing. And sometimes like I feel, boy, I'm stupid for hiring that person. He was referred to me by my cousin or whatever. And I didn't check to see if they, did they do any other work, that kind of thing. Was it any good? But typically the malum in se type things where we recognize the activity as being criminal in and of itself. Those have severe criminal penalties, as they should. And the malum prohibitum are usually civil wrongs, so there might be fines or licensure issues or that kind of thing that get attached to it. But there's not typically a possibility of jail time or that sort of thing. Well, as time went by, prosecutors are finding it difficult to prove, negligent criminal, the negligence portion beyond a reasonable doubt, because this is where we're mixing at the time concepts of negligence that are typically you have to prove negligence in a civil case by a preponderance of the evidence, much lower standard than beyond a reasonable doubt. So they were having difficulty proving it, and the AG's office at the time was the one that was handling. I don't know if it was the criminal division or even it might have been like the consumer protection division or a consultation with the two, like there'd be a reference and then they'd send it over to criminal. But they were having trouble proving it because this is where you're mixing civil negligence standards with criminal standards, and it's very hard in general to prove negligence beyond a reasonable doubt, as opposed to just having a bad result, kind of thing, or that there are, negligence type crimes have the same types of defenses, like efficient intervening causes, that something else occurred that caused this other thing to be a problem. Well, so at that time, this very shortly after this, probably in a couple of years, the statute was amended to include basically what is a strict liability provision about where if the work stops, that's that portion that got knocked out here in the proposed bill, where there's a failure. This is on page 3 of 7. Failed to perform contract agreement part, then the owner requests performance payment or a refund, and the person fails to refund, fails to comply with a plan to fix the thing within a definite period of time. Contractors were going crazy at the time, because one of the things that typically happens, back when I was a real lawyer, I used to represent some of the bigger contractors in the part of the state that I'm from, and then they would always have like subs, on their jobs. But a subcontractor, for purposes of this, somebody who's trying to do this kind of work might have 2 or 3 jobs going at the same time. They're working with a credit line, and then one of the jobs that they're on, the person fails to pay them. So now their cash flow is interrupted, and they can't meet their credit line situation, so they can't pay their employees, and you get somebody else who unfortunately gets stuck with the fact that the cash flow has been interrupted. And so when the owner requested performance of payment or a refund, and then the person failed to do it, or was unable to come up with a plan to refund, that became a criminal activity under the current statute. So what it effectively did is created a strict liability crime for something that was totally outside of the ability of the contractor to remedy it. And one of the things that I suggested at the time is, it's one thing in the criminal law. First of all, it's an odd thing in the criminal law to criminalize some sort of negligence. We do it with motor vehicles, operation of motor vehicles, somewhat regularly. But that's a little bit different kind of thing, where really what we're criminalizing is a breach of a contract here. Maybe the negligent breach of a contract, something kind of beyond your control. And I had suggested at the time, why don't you make that portion intentional? So if somebody comes in, takes your money, paints 2 boards and runs away. Well, that's happened to me a few times, to be honest, not to the, and I should know that. But intent is something, an intentional depriving of somebody of their money is already a crime under, false pretenses and all kinds of, there's other financial crimes that are out there that are not negligent oriented, but it causes intent. And what Senator Sears wanted to do was kind of protect the people who apparently, like me, can't protect themselves all the time when somebody decides to do part of the job or none of the job and take your money. And he was looking at protecting, older folks and people who of lesser means. I understand the intent of doing it. It's just hard when it is a criminal activity. It's a mixing of concepts. You know what I mean? So what I had suggested at the time is that it become an intentional crime. Yes.
Are you leading to saying that this bill now is what you wanted originally.
Yep. That's what I was
Great.
going to tell you. But it wouldn't have been as exciting if I just came in and said, I support the bill, thank you, and left. And because I'll tell you honestly, from a defense perspective and a public defense perspective, I don't care about this if this makes no impact whatsoever on like the public defense system. It's not like we got 1,000 of these cases. The only thing I will say is we get very few of them, but when we get them, our lawyers don't know what to do with them because they're like arguing, about civil contracts and stuff in a criminal contract, in a criminal context. And so it's difficult. It's not that they can't, figure it out at some point. It'd probably be better if I were doing them because I've done like on a civil side before. But I think that this makes sense, keeping the concepts of, I would say, prohibitive, consistent with what the criminal law was supposed to be about philosophically. Now, it doesn't mean the legislature can do whatever it wants regarding criminalizing what it wants to criminalize, as long as it doesn't violate the Constitution. So, it is what it is right now. I just thought it was, even at the time, kind of unfair that a contractor who, through no fault of their own, had no ability to repay because of an interruption in either revocation of the credit line or another job that failed to pay them, or that sort of thing. Contractors don't have the same, requirements of lawyers that like they hold fees and trust. Every job is funding the next job, is funding the next job, is funding the next job. Because they have to front for materials and the like. So that's all I really wanted to say about it is that to me, from the way the business works with contractors, it makes sense. I thought it was harsh to create a strict liability crime where the defendants at times, I'm not saying always, but at times had no ability to remedy, if there was a breach, either on their part, or, because of something that happened with their cash flow or credit line, that sort of thing. So that's really all I really need to say about it. And I understand, from a consumer protection standpoint, why, you want to address this activity. But is the criminal law the best way to do it? Because then that will also, prevent people from, the contractors from getting back in business. I mean, there's collateral consequences of getting multiple convictions or having, multiple victims as a result of this inability to repay if they get stuck in a situation. So, obviously it's up to you. It's not earth shattering for the system, but it's one of those things that is kind of an oddity in the criminal law as it exists now.
Thank you. Any questions?
I appreciate your testimony. I also took Latin in high school. My question to you,
Public school,
yes, I was at the high school.
nice.
And as far as I know, Latin was taught at NMU up until just until just this year, actually, is the first year they stopped teaching Latin. Anyways, the constitutional concern that's been raised, because my understanding is this is sort of a reboot of the 2015? Is the constitutional issue addressed here? Is there a constitutional issue as this is drafted, in your opinion?
I haven't seen a constitutional.
Okay. Perfect. I just wanted to make sure that the way this language was, we were threading the needle in a way that.
Yeah, I mean, it's changing the intent. That's all. And so, I didn't see it as a constitutional issue, just a policy.
I know multiple people have brought up this constitutional issue, so I just wanted to make sure from your
I'd be
perspective.
interested in what people said, what do they think the constitutional issue is?
So my understanding of the constitutional issue, and again, I don't know if it's entirely in this language or if it's in larger language, was that there's a forced labor aspect.
That, I'm familiar with the case.
Okay,
One judge at the trial level thought that there was a forced labor issue with the statute,
so with the existing statute, so this actually addresses that.
right?
Okay,
And I thought that was bizarre. That was like a really bizarre interpretation. So I can't say that my analysis of it that is that the existing statute is unconstitutional. I don't know if I agree with that. It's not right for other reasons. But we literally had like one judge who came up with this opinion, and not all the other judges are not following along. The Supreme Court hasn't ruled on it. But everybody's, especially judging their kind of opinion.
Senator Moore.
Yeah, so I think it was, they referred to 13th Amendment as far as servitude and so forth.
Yeah.
And right now, we were told this morning that there is an appeals in Orange County going in on that particular rule.
Okay.
We're waiting, it says slated for March 4th, I believe they said.
Okay.
We'll wait and see what happens with that.
Yeah. I'll ask if I don't know if we're doing it. I'm guessing that it's probably some private counsel, only because I'll see if we're doing it. I don't think we are.
I didn't realize you were following.
yeah, my follow-up, now that I have a better understanding that the current law is the questionable constitutional issue, so in your view, this is an improvement on current law?
Well, it's consistent with what I believe it should be if you're going to have a contracted statute. That's just my opinion. I also, as I said before any of you started, as I said in some of these years, there's a whole bunch of other stuff people could be charged with, even if you don't have a contracted fraud law. But he wanted that something specific, so that's okay. So it's not like necessarily if somebody's doing something, like say this whole thing went away, you can think of 3 things that they can be charged with without this being on books at all. So
Thank you.
wasn't that what we're waiting for?
Thanks, Brian.
No problem.
Maybe we can take a break until 10:25. If we can be here sharp at 10:25 because we have retired Justice Anastory, Chief Justice Anastory coming in.
Okay.
Get him about 30 minutes to speak.